From family law. Sir, please.
Thank you, Katekar sir. Very good morning, one and all. Without wasting of much time, straightway I'm coming to the topic. India is such a country. There are number of religions, sect, caste, creeds. Hindu, please listen, is the majority community in India, whereas Muslims, a minority, major minority community in India, whereas Christians, Parsis, each community has their own personal laws. So equally, Hindu community is concerned. There are comprehensive legislations exist, maybe pertaining to the matrimonial type, adoption, maintenance, property devolution, distribution. When we go thoroughly with the text of the Hindu laws, we may classify it into two. One is uncodified and other one is codified. So far as uncodified Hindu law is concerned, since long and immemorial time, we are in practice with regard to the matrimonial type, with regard to the property devolution, adoption. And after arrival of the Britisher, the codification and consolidation commenced. And in the area of family law is concerned, in 1937, so far as woman is concerned, property right is concerned, law came. And then after, number of enactments, Hindu Marriage Act, Hindu Adoption Maintenance Act, Hindu Succession Act followed. Now, I have taken a topic has general importance, and each and everyone in a life he may cross with this phase, that is partition. My subject of discussion is confined to the extent of the Hindus. I didn't touch partition, how it is affected with regard to the other communities. Being a student of Hindu law, you know pretty well there are major two schools of thought exist. One is Mitakshara and other one is Dayabhaga. At world over, the Hindu jurisprudence, more particularly the institution of Hindu joint family, is remarkable. We didn't find such sort of institution in any other legal system. Hindu joint family, how it is composed, how it is continued, and how it became sieges. First, we supposed to know, then we may come to know how it is extinct. So far as composition of Hindu joint family is concerned, there are certain prerequisite conditions. Who should be the member of the Hindu joint family? First one is the father. His male lineal descendants up to any degree of descent. Maybe son branch, maybe grandson branch, maybe great grandson, and so on, up to any extent. The wife of the last holder of the family and wives of the male lineal descendant, whosoever being got married. It includes maybe mother, grandmother, maybe aunt, then daughters. One of the feature of Hindu joint family, even illegitimate children and dasis accommodated in the joint family, Hindu joint family. So upper links used to remove and lower link used to add. So acquisition of the membership of the joint Hindu joint family, notably the condition is birth in the family. The blood relation should have, maybe being a son, being grandson, being great grandson, and so on, or by way of a marriage, and rarely by way of adoption. And one more exceptional is the dasi as well as illegitimate kids. So elders died and youngers and persons who are getting birth, they join to the family, and it goes on generation to generation till the partition is claimed and effected. So far as partition is concerned, there are two thoughts exist. One thought is Mitakshara and other one is Dayabhaga. So far as Dayabhaga is concerned, partition means physical division of a property by mits and bonds. That is actual division. But so far as Mitakshara is concerned, there are two conditions stipulated. One is severanceness of status. Severanceness of status at individual level, a member of the family being co-partner, being male member of the Hindu joint family, it consists of father plus 3 male lineal descendant. The female has no role. They are mere member of the joint family. But so far as co-partner is concerned in Mitakshara, it consists of father plus 3 male lineal descendant. So Mitakshara co-partnerly come into existence as soon as a male baby is born to the Hindu. And it goes to the next 3 generations, son, grandson, and great grandson. Upper link is removed and lower link is added. But 5th generation at all not is the part of the Mitakshara co-partner. So I'm not going to touch the how it is continued and what are the salient features of the Mitakshara and Dayabhaga co-partner. I don't think so. I supposed to waste time. So my focal point is partition. So in Mitakshara, there are two things contained in the meaning of the term partition. One is severanceness of status, and second one is actual division of property by mits and bonds. So severanceness of status means a process being a co-partner who feel, who think, who intend to sever from this united family. I want to away from the family in form of worship, in form of food, in form of estate. So your one's own thinking process to be independent, not be the part of the united, part of the joint family. This process is exist at individual level. And second condition is actual division of property. So line between severanceness of status to actual division of property takes place through one medium. That medium is communication of intention to sever from joint status. Mean unless and until one's desire, one's wish to sever from joint status has communicated, partition never effected under Mitakshara. There is a presumption of the Hindu undivided family is concerned. Under the Hindu law, the family is a joint unless and until contrary appears. And therefore, so far as Mitakshara co-partner is concerned, it is his bounden duty to communicate his intention to sever from joint status, disregard what mode one has used. Now, intention mean which sort of intention? What should be the range? Intention should be expressed. It should be reflected a formal act. It is very deliberate, and more particularly, what Hindu law expect, it should be unequivocal intention to sever from joint status. If merely saying I want to sever does not play, anyone may say anything, but unless and until it is deliberate, irrevocable, the partition is not claimed. Now, so far as the Dayabhaga is concerned, the first time Dayabhaga co-partner come into existence as soon as father is died. The very difference with the Dayabhaga and Mitakshara is, Mitakshara recognizes right of survivorship. Everyone being male member who born in the family, he born with property. Birthright is given in the joint family property. Having interest on the death, it is increased, and on the birth, it is decreased. But whereas Dayabhaga is concerned, the co-partner come into existence only and only on the death of the father. So Dayabhaga recognizes succession, Mitakshara recognizes survivorship. Here is birthright is given, as soon as baby is born, has right in the joint family property. How much right, that is different matter. Till the family is a joint, no one knows how much he has right in the joint family, because the family property is communal, possession is constructive, so far as the joint family property is concerned. It is unpredictable, it is fluctuating in a nature. On the birth and on the death, it is fluctuated. On the birth, it is diminished, and on the death, it is enhanced. So, Dayabhaga, one of the remarkable feature of Dayabhaga is the females has space, particularly mother, daughter, but not daughter's daughter or kid, no. But to the certain extent, they respect the right of the woman. But Mitakshara is concerned, absolutely no. Only male and male dominated the co-partner is. So partition is concerned, as soon as father is died, the property is concerned, everyone being member, the co-partner come into existence, and at very moment of time, everyone knows how much his share is. 1/5, 1/10, 1/12, whatever it may be. But Mitakshara is concerned, though one may die, though one may get birth, no one knows how much he has interest in the joint family property. Though he has interest, but no one knows unless and until partition is claimed. And therefore, under Mitakshara, unless and until you broken the jointness by your heart, the partition shall never be claimed. First, you sever from the heart of the remaining members of the co-partnership, then the partition process really commenced and it became abated or stopped by way of actual division of property. Now, this lecture will go thoroughly what are the subject matters of partition. If properties are divisible in a nature, then how much should be the share? If properties are indivisible in a nature, which cannot be made in the part. So who are the members who can claim partition? How much they are entitled to take this share? If a share is not given, then what should be the remedy? So if either of the member is died, then how the person being descendant of the deceased, how they may entitle. So subject matter of partition, persons having right to partition, there are certain phases, more particularly females. So far as Mitakshara is concerned, though they are not part of the co-partnership, but if a partition is taken place, then they have a right to take this share. They cannot claim partition because they are not co-partner. But if partition is going on, then they are having a right. So how much they are entitled to get? So subject matter of partition, share on partition, who can claim partition, and how the modes are exercised, how the process to express intention and communicate other members of the co-partnership is taken place, what sort of media is used, what Hindu law is expecting, and how that partition is effected. Equally, we will go thoroughly with the phases in form of a father, son, grandson, great grandson, mother, stepmother, grandmother, and so on. And if accordingly communication of intention is expressed, but the remaining member is concerned whether partition can be claimed or imposed. So there are three basic categories of a partition. One is total complete partition as to person, as to property. How many members of the co-partnership? Everyone want to sever from whatever the joint family property, movable, immovable. What should be the nature of the property? What property is said to be the subject matter? There are many members of the family who may earn something without detrimental to the joint stock more. Does it mean their earning is thrown in the joint stock? Whether one can maintain number of sorts of properties such as part in the joint family property, whether he may acquire separate property, whether he may acquire absolute self-acquired property. So classification of property may equally come in play. Now we are coming to the subject matter of partition. Naturally, co-partnership property is the subject matter of partition. Here, all sorts of properties, movable, immovable, or whatever the mode recognized and within the purview of the definition of property is something which has value in the market, whatever thing. Condition is property should be joint Hindu family property. Property should be co-partnership property. Co-partnership property may come either through or joint family property may accumulated through either ancestral, means our forefathers who left for us. They died and they left properties by they earned their own exertion without making any will. Such a property is said to be that this is grandfather and great grandfather and this is father who left the property. Such property is said inherited property, what I meant to say. Second is property earned by joint exertion, whosoever member by their own labor jointly they are exerted and they have earned something and they thrown into the joint stock through the karta, and karta is the person who is managing all the affairs of the joint stock and the members of the family. So subject matter of partition is concerned obviously all the joint family property as well as co-partnership property is the subject matter of partition. Now, if we go thoroughly with the list of the property, then we may classify certain properties are divisible in nature and certain properties are indivisible in nature, which can be formed into the pieces, which cannot be formed in pieces, otherwise its intrinsic value may be destroyed. So what should be the process is followed by the court, followed by the arbitrators, followed by the persons being panchats, who is called and who devised the scheme of the distribution of property and how according to the share of the co-partner the property is to be distributed. It's concerned there are three basic rules so far as properties which are indivisible in a nature. Shastrakars, Pratikars and Nibandhakars and the text of the Hindu law, the Rishis and Munis, they left for us certain rules and regulation and practices. And by considering thoroughly the Supreme Court and High Courts, they have given the space of all these texts and it became a precedent for us. Keeping in mind such a sort of property is concerned indivisible in a nature, then what sort of rules are to be followed? Either such property is concerned without making any division, it is allowed to every member of the family, every member of the co-partner, every member of the parties to the partition for the use and enjoyment, if everyone is assenting. More particularly, dwelling house is concerned, where we born and brought up, where we played, where we learn. These places are very emotional, heart touching. Nobody is ready to effect the partition, make them in pieces. So such sort of properties kept away and allowed all the proper parties to the partition if they are assenting to use and enjoy. Otherwise, in turn, they may use and enjoy. And if nobody is ready, then it is sell out. And whatever proceed out of the sell is distributed among the parties to the partition. What does court may do then? If parties are not so emotional with the things, then there is no any other alternative. What are the nature of the properties which can not be found in the pieces? Dwelling house. Now Partition Act according to section 2 says whenever a partition suit is initiated before the judge and he is entertaining the matter, trial is going on and he is now going to conclude the matter, what he is supposed to do? This accordingly, either he has to, by passing the decree, pass one direction for common enjoyment, otherwise the rotation he may apply, otherwise according to section 2, a necessary auction or cell process is initiated by the commissioner appointed under the Code of Civil Procedure by the code, and whatever proceed incurred is distributed according to by way of passing the decree. Family shrines, temples, idols, these are the so even places of funeral places of our forefathers. Whenever we may cross from these spaces, we became so emotional. How we can form in the pieces? So in this regard, even staircases, wells, open wells, either common enjoyment is kept, otherwise Somwar, Mangalwar, Athoda, Maina, weekly, the program scheme is prepared and accordingly the water is pumped and if the family is a farmer family. So equally staircases, how it is to be never be formed in the pieces. Therefore, either rotation or common enjoyment or last is cell proceed distributed among the members of the parties to the partition. Everyone before going to make the division of a property in the pieces or before making the scheme of the distribution of property, it is bounden duty on the shoulder of the concerned judge, on the concern of the so-called arbitrator, on the part of the so-called panchas, they supposed to do this thing first. So whatever encumbrances exist on the joint family property, first it should be taken into consideration, and surplus remain is the pure subject matter of partition. More particularly, whatever debt exists, loan taken from different sources, first is to be paid out from the joint stock. Whatever the accounts maintained by the Karta has to place before the court, these are the encumbrances on the shoulder, that much burdens and encumbrances exist. So the list is to be placed. First, that is to be sought out from the joint stock. Equally, as I said, Mitakshara is concerned, female members they are not part of the coparcenary, therefore they don't have a right by birth in the joint family. The Hindu Succession Act 1956, which was amended in 2005, the daughters given the right proportionate to the son. Then after, the daughter has a right to claim partition and take the necessary share from the partition, out of the partition. So before that, before codification, during course of this uncodified period, the female members as well as minor copartners or disqualified copartners, they were entitled to claim the maintenance. This is one of the salient feature of the Mitakshara joint family. So whosoever member who has no right to take property out of partition, a necessary provision should be met for their maintenance out of the joint stock first. One may be Dasi, one may be disqualified co-partner. For them, even the illegitimate children, for them a necessary provision should be met. A financial provision should be reserved for them. Equally, performance of ceremonies, more particularly elder members. If a co-partner consists of a grandfather and grandson, great grandfather and great grandson, aunts, grandmothers, great grandmothers. So they are at the verge of last phase. At any moment of time, anything may happen. And meanwhile, that process of partition is claimed by one of the member and partition is going to effect. So at one side, the partition process is going on, and other side, either member of the family is going to die. So necessary provision is to be met for the religious rites and ceremonies. And then after whatever surplus remain is pure subject matter of partition. without making deduction with regard to all these three, the partition is not valid in the eyes of the Hindu law. Now, persons who have a right to partition and share on partition. Father is the person being last survival of the joint family. He has one more extraordinary power. He is not merely has to claim the partition, but he having a right to impose the partition if he wish. Get lost. So, keeping in mind the being last survival, he has exclusively this right. No one else. So he can claim partition, he can take the share on partition, even he can impose the partition, even he can impose partial partition. Second one, son, grandson, great grandson, son born after partition. That is a very crucial thing I will reserve for further discussion. But just you know the list: father, son, grandson, great grandson, person being born after partition. There are two aspects at the time of a partition, whether pregnancy was detected, whether he was conceived. If yes, then what? If a pregnancy is not conceived at the time of partition, but born after partition, even begotten and born after partition, what should be his status? How much should be his share? And if nothing is given, then what should be the remedy? Adopted son. During uncodified era, there was a discrimination with regard to the natural born son and adopted son. आपणाला मूल होत नाही म्हणून अडॉप्ट केलं. And then after the natural baby is born. So there was a discrimination. The proportion and value of the status of the both of the guy is concerned. The adopted son has had lesser value. But in accordance with the text of the Hindu Adoption and Maintenance Act, more particularly section 11 and 12 is the umbrella for the adopted son. He has proportionate value and right, and he has proportionate right with the aurasa son or natural born son to take the property proportionate with the natural born son. Illegitimate son is concerned has no right to claim partition to take the property on partition. He has mere right to claim maintenance out of the joint stock. Necessary provision should be made for his maintenance, and whatever surplus properties is purely a subject matter of partition. He can claim for the deduction of the property before division of the actual property. Minor son, minority is no bar. Though one may be minor, though one may be major, there is no discrimination. Minor does not mean he has no right to claim. A widowed mother during course of this uncodified phase, she used to claim. Even court used to appoint next friend, keeping in the interest of the minor. So whenever a partition suit appear before the court through the next friend, the court is used to ascertain whether the claim is in the interest of the child or not. And once it is ascertained, it is yes in the interest of child, then court used to admit the plaint and used to issue the summon. Otherwise, court used to reject the plaint. So minor has, though he is a minor, but he has a right, but he can exercise through the natural guardian or a next friend. Absentee co-partner. This is one of the very different phase. At one side, the family is a joint and one of the member is out of station. He is bringing food to the family. He is away from the place. And in his absence, the so-called remaining members of the co-partnery, if they have claimed partition and process of division of property is taken place, does it mean he has no right? No. So he has a right. If nothing is reserved for him, he is one of the ground to reopen the partition and to get the redistributed share. So absentee co-partner has proportionate right with the present co-partner. who claimed partition. Now persons who have no right to partition but who are entitled to a share on partition. Partition claim करण्याचा अधिकार नाही because they are female. They are not member of the co-partitionary. But if someone has claimed partition and process of division of a property and making of the scheme of the distribution of properties taken place, then these four women, females, they are having right to ask a share. One is father's wife, means stepmother. Second one is mother. Third one is grandmother. And fourth one is co-partner's widow. Either of member of the co-partner is died, leaving behind his widow. Then she can represent to her deceased husband and she can ask for 1/4, 1/5, whatever, maybe keeping in mind that her husband is alive. How partition is effected? What I said, unless and until the intention to sever from joint status is communicated. First phase is at individual level and second phase is communal level. Whole members of the co-partner will come in motion. A person who wish, as soon as he come in motion to effect the partition, his desire he is supposed to express. What mode he may use, that is a different matter. And what are the general modes one supposed to exercise and exercised? What are the practices that we are going to look? But what mode one has used, that is different matter. But one thing is the expressing of intention. Intention must be unequivocal. If intention is equivocal, then there is no claim. तळ्यात मळ्यात असता कामा नये. It should be very deliberate. It should be informative. It should be communicated one. What are the modes to express intention to sever from joint status? The mode is when one institutes a suit in a civil court of a partition and suit is admitted and summons are served. As soon as summon is served, the communication of intention to sever from joint status is expressed. Then the court conduct the trial, conclude the matter, and scheme of the distribution of property taken place and decree is passed and decree is executed. The execution of decree is second phase, but instituting a suit and serving the summon is the first phase. Partition by agreement. If all the members of the joint family or co-partnership, more particularly co-partnership or members of the parties to the partition, if they are agreeing and they are setting the views that we supposed to effect the partition by mutual consent, so they can list out the scheme of the distribution and accordingly distribute the property, and they become at individual level a sub co-partner come into existence and accordingly the partition is effected. So how they come together, how they express to each other the intention to sever. So by way of partition by agreement, even oral partition during course of the uncodified era, this mode is generally in use. Everyone is used to say, yes, we will go away. Why should we unnecessarily go for trouble? So we will sit, we will resolve the issue. You sit there, I will sit here. You will use this property, I will use this property. This is for you, this is for me. Very amicable process goes on, and accordingly the partition so on. Through this oral partition, one may use to communicate their intention to sever from the joint status. Unilateral declaration. Partition can be claimed, but partition cannot be imposed. This is the general principle. If one wants sever, he may get lost. but does not mean that everyone supposed to be, no. So first phase of partition is unilateral. One's own desire, one express to other, I want to savior. I want to get away from this united family. So one can express, there is no need that everyone supposed to raise the hand and jump in the process of the partition. Partition by arbitration. Partition can be effected through appointing the arbitrators by all the members of the co-partnership. When they appointed, they have expressed to everyone, themselves and others, intention to sever from joint status. This is partition by conduct is majoritarily used at every Indian home. One may be Hindu, one may be Muslim or Christian. Conduct mean keeping mum. They are informing. The inferences are drawn up by other members of the family. Why they are keeping mum? Why they are use and enjoyment of either or exclusive movable or immovable property? Why they are worshipping at different times? While taking the food, why they are coming early or late? So by their conduct, they are showing, they are giving the masses that I want to savior from the Bhandala Bhanda Adalni. So everyone come to know that something is going on and very deliberately things are practiced and everyone is informed that they want to sever from the joint status. So this is one of the mode through which the intention is expressed and communicated. Automatic severance. There are two modes through which automatic severance takes place. There is no need to express. Res ipsa loquitur, a thing speak itself. Once a Hindu is converted to other religion, on what moment of time he converted is the point that he has expressed his intention to sever from joint status. And second one is when one marry under the Special Marriage Act with the Christians or Muslims or else. So the moment on which he converted, moment on which the marriage is solemnized is the moment where he communicated his intention to sever from joint status, and then after actual division of property takes place for so-called converter and who got married under the Special Marriage Act. Partial partition. I said that partition can be claimed but cannot be imposed. One may get lost, taking his specified share. Only father has a right, and father has a right to claim partition, has power to impose the partition. But other member is concerned, they can claim and they can take their specified share, but they cannot impose upon all that you two away from the jointness. No. So that can be taken place in two fold. Partial partition as to person and partial partition as to property. If someone is away from the joint family and some property is away from the either of the place, and as a matter of management, better to you enjoy the property. So he may do so. If he is willing, then. So among the members of the co-partnership, one or two or either some of the figures, if they want to away, they may. And whosoever surplus or remain, they became again united. Right of survivorship goes on generation to generation until the partition is taken place with regard to the person and with regard to the property. And then after a successive partition take place. Division of property by mits and bonds. Mits and bonds mean actual division of property, physical division of property. The property is distributed according to the share. If a co-partnership consists of father and two sons, if partition is claimed, everyone take 1/3, 1/3. So to the extent of a share they received physically, the share is called as partition by myths and bonds. Meanwhile, the so-called Karta has to prepare the account and bring before the court or the whosoever being arbitrators and panchats, and accordingly scheme is met. Allotment of share, how division takes place. When there is partition between father and son, father has a right to take the proportionate share with the son, vice versa. When there is partition between the brothers, just we have to read the figure mechanically and make the pieces. When partition takes place among the branches, then there is a doctrine. Doctrine of per strips and per capita will come in motion. First partition taken place between the head. But if heads are alive, branches has no right to claim partition. So far as Mitakshara is concerned. संपू का? नाही, तुम्ही बोलत असाल तर मी कशाला कंटिन्यू करू? If you are not interested, then why should I? And if either member of the co-partnership or member of the parties to the partition is died and leaving behind kids and widows, even one may be the branch of son or grandson or great grandson, then what may be the position? So doctrine of representation is applied, and accordingly the so-called widow, so-called kids, so-called branches, they can represent to their so-called deceased father or husband or grandfather, and accordingly they may take per steps, and in between the branches individually they distribute by way of doctrine of per capita. Now, meanwhile, if while making the distribution of a property, if a scheme is fraudulent, then what should be the remedy? And if unknowingly, unintentively, by mismemory, if some property left unpartitioned, and after the partition came to know that this property is unpartitioned, what to do? Then whether all the scheme is to be kept in the trash and again we supposed to go to this heavy struggle, or even during course of this jointness, some movable, some ornaments, some valued properties, some documents lost, and after partition fortunately become recovered. So what should be the remedy then? Whether again we have to prepare this rigorous process we may undergo? No. So the solution is, if readjustment is the solution, then adjust it. But if readjustment is not the answer, then reopen it. Then go for this again, for this rigorous exertion of the process of partition. So what are the grounds? When readjustment is not the solution, then how partition is reopened, and what should be the ground to reopen the partition? If a discrimination is practiced, if a fraud in making the scheme of the partition distribution of property is practiced, more particularly misrepresentation, the value of the property shown, it is either undervalued or overvalued. This is the mischief on the part of the so-called Karta. He shown something, but then after came to know has no value. the bulk and quality and quantity of the so-called item of the property is not as per the inventory prepared by the at the time of partition is not matching. जसं की सेल बाय सॅम्पल आहे, सेल करताना सॅम्पल एक दाखवला आणि पुरवठा करताना ते असं जेव्हा सेल ऑफ गुड्स ऍक्ट मध्ये होतं. सो सेम वे इफ सच फ्रॉड इज प्रॅक्टिस्ड, deceit is practiced, discrimination is practiced, keeping in mind the advantageous situation because one is absent, because one is minor, because one is illiterate, but because one is disease, having venereal disease, one is because unchasted. So it's such sort of grounds through which if share is not given or given lesser given, discrimination is practiced. Then person who being discriminated, who being affected of the inventories and scheme of the distribution of a property, either by way of panchayats or arbitrators or by way of agreement, then partition can be reopened. First ground is fraud, what I discussed. Second is son in womb. I reserved this discussion at the early moment. Now I am bringing it in discussion. Son in womb. When partition is claimed either member of the co-partnership, meanwhile, more particularly when the partition is claimed and family, the co-partnership in between the father and sons, it is expected that partition should be postponed till the arrival of the baby. If a male baby is born, he will take the specified share. If female baby is born, the necessary provision is to be met for the expenses of her marriage and maintenance. But if no share is reserved with the father, is one of the ground for the so baby being minor or even on the age of majority, he can institute the suit to reopen the partition and take the redistributed share. If son is conceived, then it is good. But if son is not conceived and born after partition, or begotten and born after partition, then he is the member of the co-partnership headed by the father. He has no right to reopen the partition and to take the redistributed share. Equally, posthumous son, a son born after the death of the father. Father had not seen the face of his kid. So he is equally entitled to reopen the partition if necessary share is not reserved because the pregnancy was conceived and well known to everyone. They supposed to postpone the partition, but they were not agreeing and the partition effected and no share is reserved. A posthumous son is entitled to reopen the partition to take the redistributed share. Disqualified co-partner. Disqualification attached to either of the insanity. If one is insane during the jointness, he is disqualified to act as a co-partner, therefore has no right to claim partition to take the necessary share. But it is expected that necessary share supposed to be reserved for him while making the distribution of property. And no scheme is met, no deduction is met. And after the partition, he became sane. Then he has a right to reopen the partition and get the redistributed share. Absentee co-partner obviously is not a disqualification to get the share, is not a disqualification to claim the partition. Unheardness, 7 वर्षाचा कालावधी आहे. ज्या दिवसापासून तो घर सोडून गेलेला आहे, जगातल्या कोणत्याही स्त्रोतनी सांगितलेलं नाही की त्याला आम्ही इथं पाहिलेलं आहे. असा कोणताही सोर्स जर नसेल आणि 7 वर्ष जर झाले नसतील तर नेसेसरी शेअर शुड बी रिझर्व्ड फॉर हिम, that at any moment of time he may come and supposed to be share with him. If no share is reserved for him and within the span of 7 years, if he is appeared, it is advent and no share is reserved for him, then has a ground to reopen the partition and get the redistributed share. Minority is no bar on behalf of minor, natural guardian, next friend, even NGOs, social reformers, child साठी काम करणारे विविध संस्था आहेत. They can come whenever we may come to know that this is the baby being co-partner, being qualified to claim the partition and get the specified share on the partition if partition is going on, but this kid is kept away, keeping in mind the advantageous situation by the remaining members of the parties to the partition. The NGO may come, a social reform may come, a person who is having sensation on the so-called things, they can bring to the notice to the court and necessary suit can be instituted and they are entitled to get the redistributed share. I'm at the last page, only 2 slides are remain. Reunion. Sir, whether once we sever from the joint status, whether we may come together again? Answer is yes. There is no bar. Law एवढा antipathic नाही. But you can come together. 2 conditions are stipulated. One, तुम्ही जे येत आहे ना ते प्रेमापोटी आलं पाहिजे, आउट ऑफ लव्ह अँड अफेक्शन. नॅचरल लव्ह अँड अफेक्शन, प्रेमापोटी म्हणणे आणि नॅचरल लव्ह अँड अफेक्शन मध्ये फरक आहे ना. हा, आउट ऑफ नॅचरल लव्ह अँड अफेक्शन दे सपोज टू कम टुगेदर. PSL तुम्हाला ट्रीटमेंटची गरज आहे. तुम्ही आमच्याकडे आल्यानंतर ट्रीटमेंट मिळेल. मला असं वाटतंय जास्त रिगरसली घेत नाहीत फॅकल्टी त्यांना. असं नका करू, हे तुमच्यासाठी आहे, आमचं काही नाही, हे आमचा आयुष्याचा भाग आहे. पण तुम्हाला चांगलं बनवणं, तुमच्या वेलबिईंग साठी हे आमचं सर्व प्रयत्न आहे. तुम्हाला हे बाहेर कुठेही काही मिळणार नाही, तुम्ही कितीही कोशिश करा, हे फुकट मिळतंय असं समजू नका. आणि हे रियुनियन फक्त त्यांच्याच मध्ये होईल ज्यांच्यामध्ये पार्टिशन झालं होतं, जे पार्टिशनचे पार्टीज होते. Those who are not member of the parties to the partition, they are disqualified. And next is a reunion can take place between the father and sons, among the brothers, and जास्तीत जास्त uncle and nephews. पण ग्रेट ग्रँडसन अँड ग्रेट ग्रँडफादर यांच्यामध्ये रियुनियन होत नाही. का होत नाही ते मला विचारायचं नाही. दिस इज द फॅक्ट. Whether minor can reunite? Absolutely no. कशामुळं? तर ते रियुनियन होण्याचा उद्देश त्या वडिलाचा, त्या भावाचा, त्या अंकलचा काही विचित्र असू शकतो. He may play any mischief. रिस्टोरेशन होतं का वडील आणि भाऊ मुलांमध्ये जर रियुनियन झालं तर? यस, राईट ऑफ सर्वायव्हरशिप विल रिस्टोर्ड. मग तेच कम्युनिटी, काय कम्युनल ओनरशिप, युनिटी ऑफ पोजेशन, कन्स्ट्रक्टिव्ह पोजेशन ऑफ वन इज पोजेशन ऑफ ऑल, हे सगळे सर्व जे सायलेंट फीचर्स ऑफ मिताक्षरा कोपासणारी जे ते सर्व आहे ते रिस्टोर या ठिकाणी होतात. आणि पार्टिशन पूर्व जी परिस्थिती होती तीच परिस्थिती आहे ते या ठिकाणी पूर्ववत या ठिकाणी होते. अशा पद्धतीने हा पार्टिशन अंडर हिंदू लॉ इज ओव्हर. इफ एनिथिंग else, it may be asked. काय विचारायचं असेल तर विचार. मला माहित आहे पार्टिशनच्या संदर्भाने फार प्रश्न असतात. इथं विचारायचं नसेल तर इंडिव्हिज्युअली पण विचारू शकतात. थँक्यू व्हेरी मच. मॅडम प्लीज. ऐका रे, इथे या ना मॅडम, इथे या. हे एक विटंबना आहे की भारताचं संविधान मध्ये राईट टू इक्वॅलिटीचा क्लॉज ठेवला. एकीकडे राईट टू इक्वॅलिटी म्हणता, वर्ल्ड ओव्हर आपलं नाव कीर्ती करून घेता. अहो किती वाईट आहे की ट्विन जन्माला आले, एक मुलगा आहे एक मुलगी आहे. मुलाला राईट आहे मुलीला नाही. निसर्गानं भेद केला नाही, तुम्ही भेद करताय. आणि दुसरीकडे म्हणताय की राईट टू इक्वॅलिटी अँड इक्वल प्रोटेक्शन. 1994 महाराष्ट्राला लागलं हे डिस्क्रिमिनेशन दूर करण्यासाठी. वास्तविक पाहता भारताचं संविधान आलं, भारताचं इथे सक्सेशनचा लॉ 1956 ला आला, पण हे इक्वॅलिटीचा क्लॉज 1994 पर्यंत महाराष्ट्रामध्ये अस्तित्वात होतं. भारतामध्ये 2005 पर्यंत होतं. महाराष्ट्र, आंध्र प्रदेश, तमिळनाडू, केरला हे राज्य सोडून. तर यांचा प्रश्न जो आहे की रिट्रोस्पेक्टिव्ह इफेक्ट आहे का, त्याच्यामध्ये फार अशा गुंतागुंती आहेत. पण 2020 ला ही गुंतागुंत आहे ते सर्वोच्च न्यायालयानं दूर केली विनीता केसच्या माध्यमातून. आणि ए लॉ प्रेसिडेंट बिकेम सेट. आणि तेव्हापासून proportionate to the son daughter has, whatever son has proportionately is exist to the daughter. याच्यामध्ये सर्व चालू, कोणतेही राहो, but alienation should not be taken place. कोणतेही असो. विनीताच्या केसमध्ये ह्याच्यामध्ये 3-4 अगोदरचे जजमेंट आहेत हे सर्व अब्रोगेट केलेले आहेत. आणि विनीताच्या केसमध्ये मुलासोबत मुलीला जो अधिकार आहे, जो मुलाला मिळतं तेच मुलीला मिळालं पाहिजे, हा अधिकार आहे ते विनीताच्या केसमध्ये आणला. एनी मोर? झालं.
Thank you very much, sir. As usual, your guidance was highly informative and useful for all of us. Today's topic was somewhat complicated topic to discuss, though it was interesting. During your lecture, you have tried to cover each and every aspect dealing with partition under Hindu law. You have started your lecture with the backdrop of partition, the schools, division of schools like Mitakshara and Dayabhaga, how they speak in the direction of partition. Then you have given the in detailed meaning of partition, how partition is effective, the persons who are entitled to ask for partition, the persons who are entitled to have share in the partition, the person who are not having a right to claim for partition but having share in the partition property. Then you have discussed the various aspects like the entitlement of partition, disentitlement of partition, effect of partition, then how reunion occurs. You have discussed the essential thing when some property is left from partition, etc., etc. All these things we have discussed in detail. Sir, this lecture was really helpful for all of us. I hope each and everybody sitting in this hall has taken due advantage from your guidance. Now, with the permission of Principal Madam, I declare that this lecture has been ended. किती वाजले